Okay, good morning and welcome to VLC Special Lecture Series Juris-JURA-2020. It is my great pleasure to welcome Professor K.R.Aithal, former Dean, Incharge Vice Chancellor, Faculty of Law, KarnatakaUniversity, Dharwad, who will be delivering our special lectures on Schools of Jurisprudence. Welcome you, sir. I would like to welcome President Vishweshwara Bhat Bangaradka, correspondent Vijayanaran KM, and all the governing council members of Vivekananda Law College, Puttur. Welcome you all. I would like to welcome Dr. B.K. Ravindra, Director of Legal Studies, Mrs. Akshata A.P., Principal, and all the teaching and non-teaching staffs of Vivekananda Law College, Puttur. Welcome you all. I would like to extend our special welcome to all our dear students and all the participants from the other colleges. Welcome you all. So before we get started, our small instructions to everyone. If you have any questions during the lecture, please type them in chat box and we will note it of that. And at the end of the lecture, I will bring them up. And one more, at the end of the lecture also, we'll be having a session for questions, queries you can ask. And without any further delay, I kindly request you, sir, to deliver a lecture. Over to you, sir.
Am I audible? Hello? Am I audible?
Yes, sir.
Yes, sir. Okay. Good morning, everybody. I would like to thank the organizers for giving me the opportunity to deliver a lecture on historical jurisprudence. Before discussing historical jurisprudence, I would like to pose a question and also I will try to answer. The question is, what is jurisprudence? And then, what are its significance? In fact, since the dawn of civilization, human beings try to find solutions to peculiar problems they face in their life. Certain fundamental questions cannot be answered through verification. So they have to be answered by thinking. So that is why to the most ancient subject is the philosophy of life, and next to it is jurisprudence. So the philosophy of life is concerned with answering fundamental questions concerning human life, like what is life, what is love, what is society. So the various answers were given by political thinkers. So the Buddha tried to find solution to the basic problem. Why people are in fact, that desire is his famous conclusion, but he has not verified. He just by thinking he found out a solution. So in the same manner, so the knowledge begins in human mind. So jurisprudence is one such subject which try to answer the fundamental questions concerning law. Just like so the fundamental questions regarding life, why that occurs. So the what is life, what is that. So that is why all sorts of religious philosophy emerge throughout the civilization, and the knowledge we acquire in this philosophy or jurisprudence is not verifiable. Like for example, water boils at 100 degrees centigrade, you believe, you agree it because you can verify it by hitting one. But at the same time, philosophical questions like what is life, what is death. For example, so why one person dies at the age of 25, another at the age of 50, and the another one, even after 90 years, his children, they think, why this fellow is still living, why he is not dying. So then, in fact, this question cannot be answered like water boils at 100 degrees centigrade. So we have to, in fact, find answers. In fact, religious. So throughout we have an answer in the religion. What is that answer? So the God has given him only 25 years. So for another it is 50 years. Like that we try to find solutions in our thinking. That is why that political thought. So the political jurisprudential thought. So whereby that we find answers to certain basic questions concerning life, not by in fact verifying, but by thinking. So that is why that in since time immemorial, bards, religious leaders, and several others are highly respected. So that is why in fact if so many people die, nobody cares. But if some very close to him, so then he tried to scratch his head and think about what is life, what is death. Similarly, in fact, that practical liars in their day-to-day life, in fact, they did not bother about what is love. But they occasionally, just like that a person died, or for example, that the loss, like what I have given you the example of Herard's decree. So that means that the baby is born on a particular day must be killed. So such a law can we accept? Or Hitler in 1945 passed a decree that whoever makes derogatory remarks against Hitler shall be punished with death. So and again the series of informer wives cases emerged after Second World War because of this decree. So that is why that some wives complained that the husbands have criticized Hitler to get rid of their husbands. They were prosecuted under the Hitler's law. Whoever makes derogatory remarks against Hitler, resign, not Hitler, resign, shall be punished with death. So some husbands, on the basis of wife's complaint, so the awarded death sentence. Fortunately, death sentence was not executed. They were again sent to front. Some survived. After they came back, they tried to prosecute the wives. And wives say that we have not acted contrary to law and therefore we cannot be punished. So, like that, this fundamental question for which no unique answer. So that is why we have different schools of jurisprudence. For example, in this case, the issue is you have studied, of course, the Austin's definition of law. So accordingly, Hitler's decree qualifies as law. According to Austin's theory, law is in command of the sovereign, enforceable by sanctions. So then, can you accept this law, this decree as law? We cannot. That is why we have studied natural law. So wherein in fact the law says law should conform to some objective moral principle. So in Hitler's decree, what objective moral principle was involved? So it is a moral principle that individual must have the liberty to speak. That too, in the law should not intervene with certain aspects of life, so the freedom of speech was violated. So if it has any, of course, any consequence on society, we may punish. Anyhow, so the schools emerged, schools of jurisprudence emerged because of different answers to this complex concept called law emerged. That is why once Thurman Arnold said, law cannot be defined precisely, but we should not abandon the attempt to define law. So then why law should be defined? So it increases our understanding of law. So everybody knows law is there, but nobody knows what exactly it is. So the jurisprudence is concerned with enhancing our understanding of law. So that it depends upon individual thinkers. So that is why you have so many schools of jurisprudence trying to answer this fundamental question, except in the discipline of law and philosophy. No other discipline you find such enormous complex answers to one particular simple question. For example, you know that chemistry people, so study of matter. For physics, study of measurements. So they never discuss more about what is physics and what is chemistry. Whereas in law, this question forms the subject matter of jurisprudence. So wherein we try to answer and throughout civilization. So the several answers have been found. Similarly, for example, you know that. So in philosophy. So the one fundamental question came, namely, who created man? So we have different answers to this particular question. According to Christian philosophy, so they emerged out, the mankind emerged out of sin committed by Adam and Eve. That is called original sin. Whereas, according to Darwin, so the man evolved from monkey to man. So this is another answer. But then, if that is the final answer, you know that one, all monkeys must have been transformed into man, but there are still monkeys. That is why this is also not a correct answer, but to a certain extent it is the right answer. Because when we rejected the existence of God because it cannot be proved, so this answer appears to be reasonable, sensible. So similarly, in fact, you know that so the only some monkeys transformed into man who propounded that genetic theory. So like that, even for law. So that is why you know that now the answer is that so the first emerged matter transformed into virus. Virus is in between life and matter. So this virus transforms into a life form. So I am not the expert in this genetics. Anyhow, so we try to find out solutions to certain fundamental questions. And the jurisprudence is one such subject concerned with fundamental questions relating to law. So it is, first question is what is law? Second question is in fact what is crime? What is property? So all this in fact, you know, that is why there are 7 to 8 theories relating to property, explaining what is the meaning of property. So then, of course, practical lawyers have a sort of aversion towards jurisprudence. They don't like it in the sense that it is a second order subject, that too by being influenced by Austin's theory of law as command of the sovereign. And of course, for day-to-day affairs, the lawyers need not answer this question, what is law? If you go and say before this court magistrate, I have summoned jurisprudence, I am an authority on summoned is authority on jurisprudence, and I am an authority on summoned jurisprudence. But summoned jurisprudence, of course, it has its own role to play, but it is not the end in itself, because no more theories are emerged. Anyhow, so that here we try to find solutions to certain fundamental questions. Accordingly, just like that five-blind man, understanding the nature of living. So the same thing in case of the understanding of concept of so wherein in fact that according to Austin, law is a command of the sovereign or an authority enforceable by sanctions or punishments. Of course, this definition also has a role to play in modern societies. And at the same time, natural lawyers, they try to argue that law is a rule incorporating some objective moral principle. For example, that so the law, we say that IPC is the law punishing murder. So it is, you say that section 302 of it. But natural lawyers say that it is not section 302 makes murder punishable. So it is a moral principle, namely killing is bad. So that is why it incorporates a moral principle, whether definition 299 or 300 of IPC is based on this moral principle, killing is bad. But it is not always bad. That is why that so there are other moral principles. Like for example, that some people have to be sacrificed, some soldiers have to be sacrificed for the survival of me. That is why murders have been classified. Only intentional killing is severely punished. So anyhow, so that is why that term set is natural law. It has created a lot of confusion in the minds of people because so the law killing is bad is not an absolute principle. Therefore, we have to define. Therefore, four kinds of homicides are. So, in certain circumstances, certain moral principles argue that we have to sacrifice some soldiers. That is why that term said. This natural law, moral principle, created a confusion in the minds of the people, and therefore, so to determine when the murder becomes punishable, when it becomes excusable, when it becomes severe, when it becomes less severe. So that is why we require IPC, positive law, or man-made law. But at the same time, natural law has its own role to play, and it revived after Second World War. But Bentham said only the law laid down by an authority. So this gives scope for Hitler to pass such decrees, or this notion that king is absolute. So that led to terror decrees, or even now the attempts are being made to enact certain laws. For example, that so the Parliament makes a law whereby so that another 25 years other than Muslims will not be recruited until their representation reaches 18%. Of course, there are attempts. That is why that law has to be evaluated. So then, in fact, that now reservation Supreme Court have kept, therefore, corporations. Maratha Corporation, Kurubra Corporation, all sorts of corporation and giving some money. Swallow. Some people politically connected will swallow. That's all. Anyhow, so the issue is, there are different schools of jurisprudence defining law in different ways. So that is why. So in this case, historical school emerged out of the weaknesses of these two schools. One is natural law and the other one is positive law. I hope these two schools have been dealt with. So naturally, all these schools are interconnected. So that one school emphasizes one thing and another school emphasizes another aspect of law, because the law is a complex phenomenon. So it is not a unique phenomenon. So that is why excessive secularism is bad. Excessive authority, absolute authority is bad. That is why that several revolutions emerged to overthrow the monarchy, because monarchy can easily be disintegrated into tyranny. That is why that French Revolution, the Soviet Revolution, all this happened as a reaction against the, in fact, assertion by one school of philosophy or totalitarianism. But at the same time, that in a society that requires supreme power, so that because every conflict must end somewhere. So then, in fact, sociological school try to study the social purposes of law. So what is the function of law? Like that. Historical school is concerned with the study of evolution of law in the history. So how it evolved? In fact, that this historical school promoted by, in fact, father of historical school of jurisprudence, Karl von Savigny, a German jurist, who, in fact, popularized the historical school. So why he popularized the school is because of the weaknesses of positivist school of law, which emphasizes every law is natural, and the natural law itself. Law consists of moral principles. So these two schools, of course, one of the most ancient schools of jurisprudence is natural law. And of course, by advent of nation states, so the supreme but controlled authority emerged, overthrowing of, in fact, monarchy and the tyranny of the rulers. So the democracy emerged. And a best way to make good law, what we require is good law, not bad law. So at one point of time, people thought that so the democracy will solve all the problems, and the representatives of the people will make good law. So this is in fact the positivists try to argue. Accordingly, political institutions emerged in an organized manner after the Renaissance in learning, where during the time of Renaissance, in fact, people questioned several theories, assumptions, and then try to introduce new knowledge, create new knowledge. So that, of course, it is the Kant whose theory of knowledge, even today, in fact, has a role to play, wherein you know that every discipline has their own fundamental principles, concepts. So whereby you know that law. So these natural lawyers try to define law in one way. So the positivist lawyers they try to define it in another way. In that fashion, in fact, you know that different schools of jurisprudence emerged, and that as a reaction to these two schools, that is natural law and positive law of honesty. So the emerged this historical school because at the time of in fact early 19th century, when Germany was conquered by France and German rulers tried to introduce omnibus codes, just like in fact Napoleonic codes. But German people, they argue, thought, respect Savigny, a lawyer, argued that this law is not suitable to our country, just like you know that in India. So even now there are many people who argue that all these laws are British rules and therefore they should be replaced by new ones. We should not obey, of course that law is not suitable to Indian society. So how you try to justify. So the law of one country, one state differs from another. So for justifying this particular aspect, Savigny first introduces the idea that the law acquires a particular character in a particular society, just like the people of particular society have their own method of dressing, their own method of etiquette, language, manners. For example, you know that you compare the costume of Arjuna or Pandavas in B.R. Chopra's Mahabharata, and then the dress of Arjuna, all Pandavas or Kauravas, according to English, Attenborough's Ramayana. Have you seen? So they are just like, you know, that ancient Greek warriors, they dress like. Whereas in Indian Pandavas, so they have their own. So there is a difference. So this difference arises on account of the influence of history, culture. So that is why you know that. So the different countries have different laws because of different history the societies have. That is why you know that in India it is very difficult to punish a person chewing pan and spitting on the wall. Whereas Singapore can do it. So that is why you know some politicians you know they went to Singapore, they could not stay there for more days. It has appeared in newspaper more than 2 days. Kachar they are visited by 3 days because they could not eat pan. So the people differ. In the same manner, the law differs. So the first assertion of historical school of jurisprudence is that the laws of different people are different. That is why even today, in fact, that so the English, British imposed law, but at the same time, that you cannot reject because that Indian Penal Code was passed in 1986 by a small legislature consisting of the officials and those nominated by British. So then can we reject that, that so the law prohibiting murder is bad because it was enacted by British people? No, we cannot. So that is why, of course, this school also I will discuss while criticizing. Of course, but the law differs. So that in India an attempt is being made, and in fact, that cow slaughter banned through law. So there are oppositions. Those who try to justify cow slaughter, they know the Chinese concept of law, whereby law is peculiar to a particular people. So we have since time immemorial. So even this fun people argue that. So we are eating farms and it is good for health. But what should be prohibited in modern circumstances is not the chewing of palm, but by the chemicals used to make it addictive. That you prohibit. Don't prohibit eating of the battle nuts. That is why all these battle nut growers once made an assertion that since the time of Mahabharata, people used to chew palm. Why you should punishing it? You can't make the law. Of course, you can prohibit the use of certain chemical substances which make this particular battle nut addiction. So that is why that the just that is how the Savini argues that the law emerges in the society by virtue of interaction with the people. So then he tried to define law as work gist or spirit of the people. So now it is the spirit of the people that it is the spirit of the people. So that is how that we have the law. In India, for example, that several rules of inheritance emerge. So then, of course, we incorporated those. For example, that so in some sections of society in South India, so we have matrilineal succession. So that we have enacted it in one law called Murumakantaya law. So it emerged in that particular society where female members will inherit the property. That is called matrilineal, Variyasanta. Whereas in certain societies, in others, so we have what is called as patrilineal succession. Only sons will inherit majority of this rule emerge in the society. It is the spirit of that particular people. So thereby, that in some sections we have matrilineal succession. In another, we have patrilineal succession. So this emerged out in the society. And one more is that primogeniture. So these three principles emerged in the society. What is primogeniture? Eldest will succeed. So then, of course, under Muslim inheritance law, so the sons will not acquire any right until father is alive. So that is why that for every ruler the succession starts with killing the father. So then in fact revolt, so whether it is in Mughal history or you will find all these things and in several other. So that is why in England the succession to British throne is based on principle of primogeniture. This is the whereby whether male or female, eldest will succeed. So that these different rules emerged in the society by way of customs and traditions that developed over a period of time. So the second aspect of the important aspect of historical school is that the law represents the spirit of the people or what we call woke justice. Woke justice, that is spirit of the law. Therefore, chief source of law, according to Sharma, are customs and traditions. So that is why you know that he also argues that the third aspect of his theory and discussing would be these three aspects. So in every society, when the society transforms into a nation state, so it develops its own laws and it grows with the nation. And if the nation disappears, either by war or any other means, the law also disappears. Of course, this conclusions, all these three important elements, you need not take it as final. Because in Europe, so the how many times you must have studied in history, the European political map was redrawn by conquests and war. So that is why you know that's because of this continental history. So Savigny tried to argue that the law matures when the national conscience was very high and when the national conscience diminishes and if a nation is dissolved. In fact, there was one state called Prussia, we must have studied in history. But today it is not that it is part of Germany. Several times the Napoleonic conquest, Treaty of Versailles. So the states, according to this law grows along with the people. And if the society collapses or state collapses, the legal system also collapses. It need not, of course. Anyhow, so these three are the three basic notions underlying Savigny's historical school. So now coming to the criticism of woke justice, spirit of the people. So in fact, you know that this Savigny's theory emphasizes the role of customs and traditions. But in a society there are several bad customs, traditions, they have to be corrected. Who should correct? So this theory undermines the importance of legislations and judicial decisions. But the social customs and traditions are bad. In fact, you know that. So the blind traditions, that is why even now, you know, there is an attempt to pass a law regulating superstitious beliefs. Or several legislations were introduced to reform the society. So in India, for several bankings reforms, law reforms. So the sati system was abolished. In spite of it being abolished, occasionally it emerges because of the spirit. So that is why the spirit is a problematic one. So that is why you know that. So the Henry Maid argued that the law may emerge out of practices of the people, but along with that, along with good practices, certain bad also required. So they have to be corrected either through legislations or through judicial decision. Whereas historical school, so they undermine the creative role of legislatures and the judiciary. So if you go and read one C.K. Allen, Law and Opinion in England. So wherein he discusses the role of law in reforming social life. So many reforms have to be introduced by in fact, the leaders in the society. Otherwise, in fact, you know that the law will become too archaic. But this influence emerges a resistance to certain reform, whether it is sati reform, child marriage, or whatever, emerges out of custom. So emerges out of the spirit of people. So that is why you know that. So the primary criticism against the historical school is that it overemphasizes the role of customs and traditions. Of course, even in England, the historical factors, that is why they argue that to the namely in England, the entire constitutional law is built on customs and traditions of the British people. So what are those aspects? Of course, you know that one is liberty, the other one is rule of law. Like that, they try to argue if you read the book of the IC's Law and Constitution in England. So anyhow, as far as historical school is concerned, so they overemphasize the customs and traditions. And another aspect of this is that if second criticism, if every law depends on spirit of the people, so the foreign laws cannot be incorporated into the system. In fact, after Second World War, so Japan was gathering the entire Japanese commercial law incorporates continental codes, principles of law. But they never, of course, other than commercial law, they never incorporate. So this, in fact, in Japanese society, so the continental commercial law became popular because it too much emphasizes on, of course, the greater emphasis on truth, honesty, etc. Whereas British common law, British Anglo-American common law system, the commercial law is in fact overemphasizes or is biased towards merchants. That is why you know that Shakespeare's Merchant of Venice. So the one rule of continental commercial code is that a contract can be declared void or invalid for inadequacy of consideration. Whereas in common law, so that you must have that the lawyers who used to teach in contract law used to tell that under common law, so Buckingham Palace can be sold for a pepper cup. So if the parties minds, they can sell it. So adequacy of consideration is not a ground for invalidating the contract. whereas in continental law, civil law countries, so the entire contract can be granted. So this aspect in fact led to the Shakespeare to write this merchant Venus where you know that so the parties can determine their own penalty for breach of contract. So anyhow, so the law differs to a great extent, to a certain extent from societies to society, but if new law cannot be incorporated into a society, this civil law cannot become popular in Japan. Or if you read the Hamlin lecture series, Settle War, Hamlin lecture. So that in India, common law has been incorporated, and Settle War argued that it has not been, it has not incorporated everything common law. That is why you know that so that we have our own laws, and that even British people also said that so that these people have their own system of personal laws. That is a political and dividing and ruling. So anyhow, so that is why you know that Savini's thesis that law emerges only in the society in the form of customs and traditions. Will not hold good when foreign laws are issued, particularly, of course, in modern, particularly in the present era of globalization. So the entire law is being globalized. So wherein, in fact, you know that more and more laws of other countries are incorporated in different countries. So that is why you know that life is also being globalized, just like you know that. So the birthday celebrations being globalized in India and China. So it is not Indian. Indians are of course dominant Indians. They used to do Shraddha, Tithi, Saptav. Birthday was not a tradition. It is McDonald's, Domino's. They popularized this birthday. So that is why now in every restaurant you have a separate section for birthday. They themselves will give candle, cake also. So that is why you know that many things people borrow from other cultures. Anyhow, so the third criticism is that so that there is a need for what we call universal law, like natural law, etc. So that is why you know that so there are certain rules which are bad everywhere, good everywhere. So they don't depend upon the spirit of the thing. For example, the simple principle that killing is bad. So you can't reject, you can't say that this killing is bad is a false proposition. Even though it may not be, we may not be able to prove it 100%, but we cannot deny the truth. Certain things are established not by verification but by rational argument. So anyhow, so that the historical school, so the overemphasizes the traditions, customs, and its role in the society. And then, of course, the third need for universal laws, as I had told you, that so the murder has to be proscribed, condemned in every society, irrespective of their history, etc. So then, lastly, of course, because of the way in which the spirit of the people are what justice asserted, it was an impact, you know, that overreaction, romantic assertion. For example, you know that relations. So you know that's the entertainment and literature. So the romanticism is one aspect. That means exaggerated. Just like that one fellow fighting with 20. So it is overemphasizing, it is not real. It is strictly false. Of course, it has a role in entertainment, not in real life. But that this overemphasis of nationalism, spirit of the people, works led to, in Germany, the racial theory of law. So the and other Hitler supporters introduced the racial theory of law, and they introduced these theories with as an extension to this theory of justice. So that is why, in fact, that historical school overemphasizes. That is what book, Poverty of Historicism by KarnatakaUniversity, a very good philosophical book. So wherein, in fact, every researcher in social science have to read that particular book, where he argues that historical arguments are need not be good always. So that is how the poverty impact that entire German historical school disintegrated into racial theory and ultimately in fact led to the Hitler's totalitarianism. So then of course these are some of the criticisms of the Savage historical school of jurisprudence. And then British, of course, I briefly discuss the Henry May's theory. So his small book, Ancient Law, which has an enormous influence, of course, it was prescribed for LLB students before 1966 or in some universities even after 3-year LLB course. So 20 marks, Ancient Law. So this ancient law, Henry May's, so it is another school of historical school of jurisprudence, and he is the prominent proponent, and in fact the Henry May's influenced in fact American Judge Holmes, and subsequently the Holmes introduced the theory of realism, realism or realist school of jurisprudence. Anyhow, so this ancient law, so that according to, in fact, of course, the Henry Wayne studies history, and he tried to draw certain inferences, conclusions from the history, the early ancient history. In fact, that, so that he argues that the law has developed since the dawn of civilization. So it has, of course, different characters, different scope, and different emphasis at different points of time in the history. So then he tried to, first 3 chapters were concerned with early history of law. So according to May, the law developed in the early history in the form of customs and in the form of servants, decrees issued by the kings, and this, in fact, they developed in the society for the purpose of promoting mutual convenience, smooth life. That is why, according to Henry May, so the early legal development. So Henry May concentrates on development of law in the history of mankind, and sometimes that this school is described as anthropological school of law, because so the anthropology is concerned with evolution of man. It is a slow process. So the evolution of life. So from, in fact, that viruses to man. So it it was a slow process. Millions of years ago, at one point of time, dinosaurs ruled this, that. So in the history you have studied. So the law develops when the history marches. So the legal development, and thereby, by studying all these things, this in early society. So the first important aspect of Henry Main's theory is that the law begins and ends with the court. Whether it is, in fact, Henry Main's first assertion by study of that early history of law. So in early society, the law started with customs, then law. Those customs were in fact modified and applied by the judges and the lawgivers. Subsequently, all these customs were codified in the form of an omnibus code. So ancient codes were 12 tables. In fact, these 12 tables consisted of early Roman customs incorporated so that they can be easily applied to resolve disputes in the society. So one Kannada translator has translated these 12 tables into 100 pages. Of course, so that is one of my colleagues. Maybe the issue is, so even in early societies, there were codes. For example, it may be Madhu's code, or it may be 12 tables. So even in ancient society, so the laws were developed into codes. But then, of course, why these codes have disappeared? So according to Henry Main, these codes simply incorporated ancient customs and practices. So then that when the society develops, people found that certain of those customs and traditions are not suitable to the particular context. For example, many customs we have many impact, that, so that is why, that, so that some people they try to assert that the ancient customs are good, just like in fact, that, so that this, what's that, go actions. So it becomes very controversial in modern days. In fact, that Indian society might have, in the early history, might have given a special superior spiritual status to cow. But these people, those who eat Muslims, Christians, and others, they believe that it is just like another animal like goat. And in fact, that one of the staple food, cheapest food is beef. Only a few people, they claim that we want to protect this. That is why, attempts are being made to introduce so the cow slaughter ban law. Of course, you must have studied in the Hanif Qureshi's case and all. But it is not possible to prevent. Cow slaughter, only thing is that because a particular breed of now several breeds of cows are there. So our cow, ancient, and if it is there in still, so only such cows can be protected. That is the argument of some people. Because this cow has become, in fact, the cheapest and most staple food throughout the world. Except, of course, a few vegetarians. In fact, even in India, purely vegetarians are only 3%. The recent study has established. Anyhow, so in that case, so the law developed, but the particular law developed at a particular point in the history need not be suitable at a different point of time. So that is why the second aspect of his theory. Then how to change these codes? So once coded, it becomes rigid. So that is why the Henry Way's quotation that all legal development begins with code and ends with. But then in fact these codes have to rules contained in the codes may become obsolete. That means they will be outdated. So those rules may not be good in the changed circumstances. Modernization. That is why the conflict between tradition and modernity. So that is why Henry May argued that three agents of legal change emerged. So the fiction, equity, and legislation. These are the agents of legal change introduced by the society. So in the early society, the fiction. So the certain fictions still there. And we have even in the legal, of course, that fictional theory of corporate personality. So many things, in fact, that are in the mind only. It is fictitious, it may not be in the. So that is why even this fictitious aspect of law. So according to Scandinavian realists, all legal rules are fictitious. They are not real. They acquire their existence only when this fiction is applied to a particular fact situation in the society. So that for example, so the rule of primogeniture. So there is in Dharwad cases there, that in fact, that. So according to this tradition, that the headship of the temple should go to son-in-law. But this Ratnavarma Hegde was very, in fact, that. So the politically more powerful. Then he introduced this idea, that primogeniture principle. They argued before the Supreme Court and got an order to this that. Because customs have to be proved as a matter of fact. So the continuity of customs have to be established. So that is why this man understood detail. Anyhow, so the custom through, of course, social interaction. So by developing certain fictions. For example, that we have so many fictions qualifying legal rules. For example, that so in marriage itself. So the law provides that unless there is a custom to the contrary, this is the rule. So the rule is that, let us say that the marriage, consanguineous marriages are one. It is a general principle. So even that, in fact, the Indian system of what is that? Jataka. So it is also based on this principle. But so many exceptions were introduced. Like for example, that. So the Jataka is not required. Jataka. If there is a marriage between certain cousins, so or even cousins, for example, that sister's son and another brother's daughter can be married. It is a fiction. So like that, there are several such fictions. They modify the rules, and that is how the law develops. So then, in fact, the particularly another is equity. It introduces, it changes the law. For example, that. So in English law, so we have a rule. What is that? Kevet yapta. That ruled the roost until the emergence of kevet vendita. That is why you know that. So the entire consumer law through legislation modified these laws. So that in England, of course, that is why you know that in early 17th century, House of Lords in one decision said that so that a person ordering for a natural diamond, getting an artificial diamond by the seller, American diamond. So he filed a suit, and then you know that House of Lords said that buyer beware. How can this poor fellow be aware whether this fellow is an artificial diamond when he has ordered for a natural? No remedy. So that is why in England there was strike and all. In fact, so in 19th century, early 20th century, against this rule. So your entire Sale of Goods Act 19, not 5 in England or 25 in India, emerged out of the exact limits of this caveat. But even today, you know that lawyers apply on behalf of the shopkeeper with the no discretion. So that is why the law develops. The law regulating the relationship between buyer and seller in a market has changed. So this principle, in fact, earlier it was emphasized. That is why you know that the person who was given an artificial diamond while ordering for a natural diamond has no. But now it cannot be. That is the case, you know, that you cannot purchase. If at all you have to purchase, you must keep one. How to distinguish whether a particular diamond is natural or artificial? So you have to keep one cathode ray oscilloscope. So that we can distinguish between natural diamond and artificial diamond. So that by verifying the X-rays will pass through natural diamond, whereas the X-ray will not pass through artificial. Can you keep the X-ray cathode ray oscilloscope producing X-ray while purchasing diamonds? So anyhow, so the issue is the law has to develop, and ultimately the another legislation. So these are the agents of legal change by virtue of which the courts transform. That is why you know that even in America, in England, or in France, continental countries. So the courts are modified from time to time. Of course, there is a role to play. These courts, the law will be more certain. It eliminates the judges' bias and predictions. That is why we have to write in Napoleonic Code about it is to another reason is that the hostility towards judges, pre-revolutionary judges and bureaucrats. So they acted in fact according to the will of the monarchs. That is why French Revolution. And therefore, immediately, of course, when after revolution, you know, this judges' power to lay down rules, law was taken away, and a separate. But any dispute between individuals and the government should be decided only by the representative, that is National Assembly. So the court, highest court, parties, cassations power also taken away. But within 6 years, of course, Napoleon introduces separate courts, administrative courts. Anyhow, so the courts are required. they cannot be easily dispensed with. So these are the agents of legal change, instruments of legal change. So then, how this change occurred? So the third aspect of Henry May's ancient law is that so the movement of law is one famous dictum hitherto as a movement from status to contract. So the central idea underlying law and legal system in the early law was governed by status. So that particularly, in fact, this idea was developed because in ancient society, so people, individuals' rights are determined not by their will, but by their status. So that is why these kings and their inheritors, successors. So they enjoyed certain special privileges, even now also. The British monarchy is maintained by taxpayers' fund, just like that, So that their status determined. For example, the master and servant relationship in early society is based on status. Slaves are only servants, they cannot be. Even Aristotle justified slavery, Christians justified slavery. So then, in fact, So all of us, of course, first England was to abolish slavery, and the House of Lords in Somerset cases meant that all slave owners have to be paid compensation. Whereas in India, land reforms was introduced. So many immediately land was in fact, So the one fellow has become landlord, another has become landless. And so, of course, that is why our land reforms law has become controversial, generated so much of litigation. Anyhow, so the issue is, the third aspect of Henry May's anthropological school is his dictum. The movement of the progressive societies has either been a movement from status to contract. So the early law was based on status. That is why that in early ancient societies, so the pater familia, that means so the head of the family, even in India, giant family. So the rights and duties, responsibilities of head of the family is different from that of other members of the family. And in fact, in early Greek societies and Roman societies, particularly European, so a father can come in case of distress. The sons or even wife to the slavery. So that is the powers of the pater familias. But not so in modern society. All marriages were conditioned in India. Until recently. So by various status, caste status, this status, and then in fact, that. So but no marriages emerged out of what is called as free will. So then, in fact, marriage law, at one point of time, that Supreme Court itself has held that a marriage solemnized without Saptapadi is wife. That's our case. So this decision was based on the status. In fact, in India, of course, the uh, marriage law is based on the status principle that marriages cannot be dissolved, continues for seven incarnations. That is why acceptable. But if you legalize, what about Prof.K.R.Aithal marriage? Prof.K.R.Aithal marriage. So in other communities, Muslim group, so no Saptapadi is there, or for Lingaites. Of course, now the bridegrooms will be very happy. If the rule is they can easily get divorced. If the marriage is performed. That is why that judges are prohibited from laying down general rules. It is the legislature should lay down because that. So they have the strength, the ability, means to know about the society practices. Anyhow, so this is the laws are determined by status, even commercial laws. So the contract, in fact, that there are certain types of contracts we cannot enter. So all this entire legal, according to Henry Day, to the based on status, it moved gradually to free will or contract. So this is in fact, the Henry Days. Another important contribution to jurisprudence. So then of course Henry May's theory, unlike the Series theory, never asserts that the customs or traditions, fictions, are the only source of it. He emphasizes the role of legislation also, but his dictum, the movement of progressive societies, law in progressive societies has moved from status to contract. Of course, hitherto he had used, but now in fact, that immediately after industrial revolution, to the labor law, at one point of time, based on slavery status, moved to free contract. So there is contract of employment, and it moved to after the emergence of labor law to the status again. So your salary is determined not by free will of yours, but by the post to which you have appointed. Of course, this free will has created a lot of problem, freedom in ameliorating the conditions of working class in America, particularly two American decisions, Atkins versus Children's Hospital. So this exceeding time. So this dictum has been criticized. So then, lastly, in fact, the historical and anthropological school emphasizes the role of customs, traditions that exist in a society in making the law effective. Therefore, this particular school of law has its own role to play in understanding the nature of law. So thereby, it emphasizes on what is called as the evolution of law or development of law in societies. I think with this let me conclude. So if you have any questions, you can ask. I think all of you might have learned something, even though I could not, of course, explain in Kannada. It does not mean that I cannot explain, but because I wanted to compress more information, and I believe that you have understood. So, you have any questions, you can ask.
Thank you for your wonderful session, sir. If there is any questions, You can ask, you can type them in your chat box. I think there is no questions. Okay, so we'll step into the last session, that is vote of thanks. I request Sangeeta SM, Assistant Professor of Law, to render a vote of thanks.
It doesn't matter where you go and what you study. What matters most is what you share with yourself and the world. So I take this great opportunity to render a vote of thanks. First and foremost, I would like to thank today's speaker, Professor K.R.Aithal, for the time and effort you took to share your thought and experience. Thank you very much, sir. And also, I would like to thank all the governing council members of Vivekananda Law College, Puttur. And I would like to thank Dr. V.K. Ravindra, Director of Legal Studies, Vivekananda Law College, Puttur. Thank you very much, sir. And also, I would like to thank our principal, Mrs. Akshita AP, for supporting us. And also, I would like to thank all the staffs as well as non-teaching staffs. Thank you very much. And also, not the last, but I would also like to thank all the students and the participants. Thank you, one and all.